Join former FBI senior forensic examiners Becky Passmore and Stacey Eldridge as they dig into the world of digital forensics, one bite at a time. Now leading their own consulting firms and educating the next generation of cyber sleuths, these badass babes of digital forensics bring sharp insight, real-world case experience, and a dose of humor to the bits and bytes that build today's investigations. From deep dives into business email compromise and ransomware attacks, Becky's specialty, to cracking the complexities of iPhone forensics, Stacey's obsession, this podcast delivers insider knowledge for professionals, students, and true crime techies alike. If you've ever wondered what really happens when the digital trail is all that's left, tune in and start parsing the truth.
Welcome back to another episode of Parsing the Truth, one bite at a time. I'm your co-host, Stacey Eldridge, and as always, Becky Passmore is right here with me.
All right, good evening, everyone. We're very excited to bring you another episode of Parsing the Truth, one bite at a time.
Now, we've spent 5 episodes reviewing the digital evidence and testimony related to the Casey Anthony case. We've reviewed the testimony of the 3 expert witnesses who testified in this case, Sandra Osborne, Kevin Stinger, and John Bradley. Now, John Bradley, who testified for the prosecution, chatted with us in episode 14, reviewing his testimony. And then we also spent episode 15 speaking with the defense expert, Larry Daniel. Now, in this episode, we're also going to be bringing in some discussion that we got some inside tips straight from the people who worked for the Orange County Sheriff's Office. Now, clearly, we've done a lot of work on this, and we've done this so we can get to the root cause of the myths, the alleged problems surrounding the digital evidence in this case, and we're going to talk about everything we've learned from it and how it can be applied to digital forensics today, 14 years later.
What is the problem with the digital evidence in this case? It really centers around the fact that different tools produced different results when parsing internet history. And so this is the myth of the 84 searches of chloroform. Specifically, this digital evidence centers around the deleted MORC database that contained Firefox history. Remember, this file was manually carved from unallocated space, and in court, it was revealed that it was parsed with both net analysis and cashback. In the first bizarre twist, the state had John Bradley testify about the cashback report. Remember, he's the one that is the developer of this software. They had him read into the record that there was a visit to the chloroform website. We're going to share that later on. And that website is the www.scispy.com, chemistry, chloroform.htm. Later in the series of this bizarre things in this case, the defense has Kevin Stinger testify that net analysis reported that the same chloroform website had only been visited one time. Kevin Stinger also testified that the reports were different.
And I think that's where a lot of the trauma for digital forensic examiners really started. But before we started digging in, we didn't have any idea where these discrepancies came from, nor did we have any idea where this research and these interviews with people would lead. And it was certainly revealing to us to dig in and get all of these facts assembled and put together. And we've also talked to other examiners who remember this case from, 2011. The trial going on. And let's just say they were surprised to learn what we're going to be sharing with you in this episode. And we hope that you're going to find this just as eye-opening as all of us.
Yeah, it was completely fascinating. I believe during this conversation that we were having earlier in the week, we were both mouth-dropped wows of the unknowns that we didn't have the information on. So that was very eye-opening. What we have to remember is people have lots of feelings about this case, and that's for a variety of reasons. The myths are plentiful in this case, and along with some finger pointing, it's easy to say it's a tool problem or a validation problem and a validation problem. Now remember, we're not here to judge guilt or innocence, but to highlight the critical role of digital forensics, digital evidence, processes, methodologies, and expert testimony.
All right, it's a tool problem. Review your results, people. End of episode. I'm kidding. We've got lots more to say. But once you take a step back and actually review the testimony that was given in the case, the facts of the case, and not everything was known to the public or even everybody that was testifying. But what's clear to us 14 years later is there's no bad guy, there's no lazy guy who just ruined this case. It's a bizarre set of twists and turns that were so common in this case. Now, if you thought you knew everything about the Casey Anthony case, this episode is for you.
We are very fortunate that we are going to share a lot of insider knowledge today as we break down what happened while presenting the lessons learned from this Casey Anthony case. First up, the cause and the myth of the 84 chloroform searches. So in the opening statement, the state mentions that you would hear testimony that a user searched for chloroform and how to make chloroform. Then Bradley comes in and he reads into the record from the cashback report that there was a visit to that sizespot.com chloroform so that's what happened when he was called to read that into the record. And then he only read the website and the date. He did not read the number of visits during the initial testimony and during the direct by the prosecution in this trial.
Right. So the key point there is initially when he revealed that website, he did not utter 84 when the state had him on direct.
No, he didn't. He did not. He did just read into the record from the cashback report about that URL. That's all he did. But, however, later on redirect, the state asks how many times the sizespot.com, the chloroform site, was visited, and then he says 84.
Right. And so on that redirect, remember, it's the state went, the defense went, and now the prosecution is going again on the redirect.
That's right. So the next morning, the defense on cross asks Bradley, now yesterday when you mentioned the 84 visits to the sizespot.com, you don't have 84 URLs in your internet's history, do you, sir?
And his answer was no.
Yeah, exactly. And the defense later called Stinger to the stand, and he testified that Net Analysis only reported one visit to that URL. And then Baez even had Stinger walk backward through internet history that it was, in fact, MySpace that was visited 84 times and not the chloroform site. And he actually had Stinger walking it back by saying, visit 84 to 83 to 82 and so forth. I feel like that was kind of like counting down 99 beers on the wall. But anyway, even though in the court, they clearly discussed visiting the sizespot.com chloroform sites 84 times, or was it one time? And then here comes the media, and the media explodes everything and doesn't understand the terminology. And now they're reporting that it's 84 searches.
Yes.
The media can push false information out there so easily. And so then here comes the lessons learned. This goes back to one thing, and that is do not believe everything you hear in the news, right? The news does not understand the terminology. They take something and they explode it into the news. And then the other thing, watch the testimony and read the transcripts versus relying on what the media has to say.
Right. Because I've been in the courtroom before. I was there listening, testifying, etc. And then I come out, see some news articles, and I was like, were we even in the same courtroom, you and me, Mr. Reporter? Because
Exactly.
this is not
That's not
matching
what
up.
happened. Right. Exactly. Yes.
And I think part of this was headlines for sensationalism, right?
And again, they hear the word internet, they hear the word 84, and they just conclude with searches because that's what they think that they're speaking about. But that's not exactly what they were talking about in this context of the courtroom.
Right. I think, Becky, you've mentioned a great lesson learned here. Go straight to the source for the facts. Don't rely on the media.
That's right. And if you don't understand the terminology, ask someone who does. Like, hey, what do they mean by this versus what do they mean by visits versus searches?
Right. Yeah. And there had been a ton of media coverage in this case from the beginning, from 2000. Now, we've mentioned the chloroform website. And so I thought it would be interesting for us to show you that chloroform website. Now, remember, in the trial, all they did was read URLs into the record. They didn't show anything. There wasn't any visuals. Imagine, as a member of the jury, trying to keep track of, oh, they went to this website and they search for all of these terms, and they get printouts of it later on. But this trial was more than a couple of days long. And if you can use a visual, as they say, one picture is worth 1,000 words, showing these websites could have been very, very powerful. So I am going to share my screen here, and I'll read through it in case you're just listening here. Now, first, I want to explain that I use the Wayback Machine. The Wayback Machine is kind of like what it sounds like. It is going way back in time. You can pick certain dates if they're available. The website is actually web.archive.org, and they archive tons of websites. And fortunate for us, 14 years after the trial, 17 years after the investigation, we can pull up what this website looked like in April of 2008. And you have to use your judgment. Do you want to go a little before the search date, the visit date, or do you want to go a little after? And I went with a little after. And you can see here that the archive date of this is April 6th. So it's not too far after March 21st. And this is what I went with. And so this is the website. You can see down here at the bottom, it has the whole URL. So this is the one that was focused on a lot in the testimony, where it's sci-spot.com/chemistry/chloroform.htm. That was the one that they were hotly contesting. Was it visited 84 times or was it visited one time? What this page is a stop and read before continuing. This is just the warning page, and it says how dangerous chloroform is. And throughout this, Becky, we learned really a lot about how dangerous chloroform was. I had no idea.
I had no idea.
So that's why they've got this up there. And this is before it was certainly out in the news, remember, because the reporting of the missing child and everything and the Casey Anthony arrest wasn't until the summer. This wasn't what the website looked like in the spring. So they always had this. And if you want to see how to make chloroform, you click on the continue link, it opens up this other page. And this one was archived a little bit earlier on April 4th. And I'll go down here and show you the URL at the end. But this is the sci-spot.com/chemistry/chloro2.htm.
Yep.
And this was read into the record as well, but they really didn't harp on this one. Now, this is where you get into the details. It tells you kind of more about chloroform, and then it gives you the procedures of how to make chloroform. And I personally think this would have been very powerful to show this during the testimony.
We're talking so many years ago.
Right.
Again, where this, that this case, like other cases was the infancy of digital evidence being entered into court and spoken about for the first time, that now it would be very common for
Right.
these types of things to be brought in as evidence. And I just feel like back then, maybe it just wasn't talked about as much as it is today about bringing these in as examples, exhibits, showing, demonstrating, looking at it. Because I feel like if you, as a juror, as someone trying to make, go through the case details, seeing something like that would be much more clearer.
Right, because they were expecting the jurors to put together, okay, first there was this Google search of how to make chloroform. Well, and then they go to SciSpot, chloro, what? Then they go to chloro 2, what? Like, what is the significance of that? How does it tie together? And you have to remember the defense was like, oh, there was this picture on MySpace, on her boyfriend at the time's MySpace page. Win her over with chloroform.
Sorry.
The story was Casey Anthony didn't know what chloroform was.
Right. Right. And again, it goes back to a visual. You spoke about it, and the fact that a picture or a visual, it speaks volumes.
Yep, absolutely.
With that Wayback Machine and that internet history, why was the cashback report even used, and why was Bradley used to read that report in, Stacy?
From what we're told, the prosecution felt like it would be better to have the tool developer read the results in because they were very nervous about things being challenged and debated. They wanted to be very conservative, and they thought, well, if we have the tool developer come and read it in, talk about it, he knows all the things about the tool. He's very well versed in how it was parsing. He's also very knowledgeable in how the browsers work and internet history. And that was very obvious in our conversation with John Bradley as well.
Exactly. That's right.
And I think because they could get Bradley there on the stand to do all of that stuff, I feel maybe that's why they went with that cashback report.
Right. And it had the details that they wanted to be entered into court, into as an exhibit.
Right. Because chloroform was very important for a variety of reasons that we've not discussed on this show, but it is very important in the case.
Absolutely. So the rule was invoked, and we've talked about that rule being invoked previously. But what we didn't know was that Baez subpoenaed everyone. We've always talked about, wasn't it interesting that the defense calls in the state's witnesses when he had his own witnesses, he had his own expert witnesses that he never called to the stand.
Right.
And we're like, how and why? Well, we learned through our insider.
And Larry gave us some insider tips too, as the defense expert.
Absolutely. That Baez subpoenaed everyone.
And we just found that out. Just found that out.
If the state subpoenaed them, Baez subpoenaed them before the trial. So whatever the state's witnesses were now the defense's Baez witnesses. And so that was a jaw-dropping moment this week as well when we spoke about that. So once the trial started, then there was no talking among any of the witnesses.
Which is pretty much the whole sheriff's department by the, the time the trial rolls around, who didn't work on it.
Absolutely. Having to testify, you're not allowed to talk about the case. And none of these witnesses, Osborne, Stinger, they had no idea what Bradley was saying, nor did Bradley have any idea what Osborne and Stinger were saying. They couldn't talk, nor could they even just talk to Bradley until the defense excused them. So once they're excused from trial, then they can have a communication about what was said and what was discussed.
But one of the things a lot of people wondered with this conflicting tools is, why didn't Stinger try to explain away the conflicting tool reports? Because he just said they are different. And again, a lot of people in digital forensics got really upset about that. And that's why we brought up the rule. We have to remember that that rule was invoked. So Stinger had no idea what has happened in the courtroom, and he had to keep it simple. And he just said they were different. And he didn't know why at that time, why they were different. And so he just left it as they were different. Now, when he was going into the trial and during the trial, he was also under the impression the entire time that they, as the prosecution, were sticking only to the Google searches. That's all they were going to bring up from the cashback report. They weren't going to read any of the other websites that were mentioned, especially not that SciSpot.com. Stinger was very clear with the prosecution. He wasn't comfortable with that website and the results about the 84 versus the 1. He didn't know why they were different, and he believed they were going to stick clear of that. So he just said they're different. The defense didn't press him any more than that. And so that's the way it's ended. And I thought, Becky, here would be a good discussion point of like, how much is too much to stay on the stand? And where is that line of like short and sweet and explaining it all away?
Well, we also have to understand that sometimes saying too much, it opens up that area of questioning, right? To keep it simple and not open up that line of questioning in hopes that your counsel will come and redirect and ask you more questions to be able to explain the information, it appears that that's not what happened here. It appears that it was just left as they were different. And I think you and I have had the discussion this week about the fact that sometimes you can't say anything else, because what happens if now you're pushed into the corner, and how do you get out of the corner without, of trying to explain yourself even more? So there's nothing wrong with saying they're different. There's nothing wrong with saying I don't know while testifying.
Right.
And again, it goes back to the strategy and the understanding of the prosecutors. You stated here, Stanger was under the impression they were sticking only to the Google searches, because when Stinger communicated with the prosecutor, that was what he recommended, because he knew they were different.
Mm-hmm.
And because the prosecutor didn't stick to what Stinger had recommended,
Right.
it opened up this other line of questioning where all Stinger needed to say was they were different, in hopes that the prosecutor could come back and hope to explain why they were different. And that didn't happen either.
Right. And to your point, he was a witness for the defense. So the defense got the first shot at all the questions. But after he answered those questions, the state had the chance to do the cross on their own witness. But obviously, it's like their witness. So they want to make him look good and keep his answers in line with their story. So the state could have asked him to explain it or justify it or clarify it or any number of those things, but ultimately they didn't. And I don't know if it was because they thought, let's just leave it at they're different and we're not going to dig the hole any deeper with these conflicting reports, or maybe they didn't know what to ask to make it better. And you certainly never want to be the witness on the stand going, but, or being like, and like making crap up as you're on the stand either. So
absolutely. You never want to do that. And that's the other thing, is you're expert for the prosecution when communicating with them and recommending where to stay, what lane to stay in. When that line is crossed, it really puts the pressure on the witness sitting at the stand to say, okay, I have to answer truthfully.
Certainly going into this, even Osborne, when she was called first before Stinger, they had no idea what the defense was going to ask them when the defense called them as their witnesses. You're out for yourself here on the stand. And, I'm sure they could have role played it and guessed what crazy things might have been asked or pointed out on the stand. But, rely on the facts.
Exactly. Rely and report on the facts. Exactly. That's all you can do. Yeah. So let's talk about those conflicting tool reports, right? So how do we end up with two different tools reporting different results? And then how did those conflicting reports end up being key part of the defense's strategy to shed doubt on the reliability of the state's evidence. So if we tackle the first part of the first part of the questioning, the two different tool reports, we found out this week that it's actually four.
I know,
different tools,
Four.
not two that was only brought into the testimony and the courtroom and the readings and all that of cashback and net analysis, but there was four different tools, and we got that inside scoop, and it was net analysis, NCASE, cashback, and FTK. All four tools produced different results. First of all, that just gives me like anxiety thinking about it, right? It's just like, oh my gosh, I have four tools and they've reported differently. So it was said in the court that Stinger didn't like the fact that net analysis could not handle daylight savings time, which was included in that MORC database. He went on to go out there and search for a better tool to help him validate, understand, verify the evidence. And that's where we get four different tools.
He kept looking and looking. And I mean, 4 tools later, and really at that time, that was kind of all there was, because you got to remember, NCASE and FDK were the two big forensic tool suites, and then net analysis and cashback were the only ones outside of the big tool suites that could do the parsing of that MORC database.
Right. So at the time of this investigation, you used the 4 main tools that examiners were primarily using back then, and it was reporting on that information and evidence different results. And that's where understanding our tools comes in. Like, just don't report on what the tool is reporting on. I mean, just don't communicate what the tool is reporting on. Understand it. And I think this is very clear that that's what Stinger was after, the answers to the questions as to why this was being done this way. Ultimately, the Orange County Sheriff's Office was unable to validate that SciSpot.com, which was the chloroform site visit, and they even tried manually walking through the data and could not get there. So the prosecution strategy, as they conferred with Osborne and Stinger, was to be very conservative, to not use any of that internet history that could be easily debated or challenged. And that's exactly what happened. And so it was challenged in court, and the testimony was supposed to be focused primarily on the Google searches only. Again, a breakdown in communication. The Orange County Sheriff's Office had it right. They had it right because they used multiple tools to try to validate the evidence. They had it right because they knew that it could be challenged or debated, and what they felt like the best evidence to be presented in court was. And ultimately, the state prosecutor, the lawyer, has Bradley read in that SciSpot.com website and other websites into the record.
And then she has him go back on the redirect to be like, and how many times was it visited? And then that's when the 84 comes in, and then it just waterfalls down from there of a lot of back and forth.
And then during that recross, after Baez is trying to get what we assume is the net analysis report results of the one visit to the chloroform site in through Bradley, the state's going to object on that, so that conflict doesn't come up later until Stinger is there. But what it tells us is that the defense is well aware of the conflicting number of visits, and again is trying to use that to their defense strategy.
Right. And it came out in the trial, right? So there was the 84 in the chloroform, and then Baez is trying to get that net analysis report in with the one hit through Bradley, and the state picks up on it because Bradley's like, what is this? This isn't my report. And then the state's like, this isn't your report, and they start objecting, and so it doesn't get in. Larry told us as much in his interview that they knew that there was conflicts and the results didn't match up, so they knew that. What their strategy was ultimately without the the state bringing up the 84, who knows?
Again, We also know that as a trial is moving along, their strategy is changing like a chessboard.
Yep.
They're looking to see what's going to benefit them as evidence is brought into court. So there's three things to take away from this: the ability to follow this information, the role of tool validation, and your role as an expert versus the role of a lawyer. Being able to have those attorneys understand what you're trying to communicate is critical. That is so key in investigations, especially in trials.
Right. If they don't understand what's important, then they might not ask about it. They might not harp on it. And if they don't understand, like in this case, why it's so important to not use something, they don't understand the can of worms that they're opening. And the thing we have to remember as expert witness is what's our job as the expert witness. So Becky, like what's our job as the expert who's testifying versus the lawyer's job?
I mean, our job is to tell the truth. Our job is to state the facts. Our job is to articulate the findings that we have located and be just very clear in explaining the details. Our role is to communicate not those findings to our investigator, but to the attorneys, and ultimately make it very clear if testifying to the jurors.
Right. And this is so much different than the role of the lawyer because the lawyer gets to ask the questions and the lawyer gets to decide what evidence is brought in during the trial. We can certainly talk till we're blue in the face before the trial about what we think and do our recommendations, but ultimately the lawyers are up there doing the song and dance with all the witnesses and bringing in the evidence that they want in the case that supports their strategy for the case.
Right. And again, that makes a perfect point of you have a prosecutor, a defense, and a judge. Ultimately, those three are the people that allows evidence to be entered into court. It can be objected. It could be a hearing could take place beforehand to even have evidence not submitted into court. So again, in the end, that's the role of the attorney. Our role is to clearly understand the evidence, to be very clear and concise in what that evidence is stating. And like Stinger, you have two reports here. Those two reports are entered into the court as an exhibit, and they're different.
And I think we've hinted at this information in the trial, even going back and rewatching testimony and rereading transcripts, it's hard to follow what is happening. And I understand digital evidence. And I mean, granted, we're looking for some very particular things here about like the 84 and who introduced what in what order. But when we're trying to go back and dig through that was very difficult. Bradley's testimony alone was nearly 100 pages. So that's a lot of information to absorb. Just imagine the jury trying to follow just this part. And then they got all of the other stuff that they had to listen to as well during the trial.
Absolutely. So let's talk a little bit about validating.
Mm-hmm.
So do you have to validate everything?
In my opinion, you don't have to go through every single time in every single case and validate every single record. However, I do validate manually or with another tool the smoking guns of the case, especially if I'm going to be going to court and testifying on this. Those specific records are the ones that I'm going to be double checking and making sure that they match up, that I understand them, that I understand how the tool produced what it produced. Do you disagree, Becky? Do you have to do them all?
No, I mean, obviously there's mounds and mounds of data when any case, whether it's a cell phone or a computer, whatever type of case you're working on. So did the tool report properly? And if it didn't report properly, then validating with another tool or manually validating it. And there's nothing wrong with doing a comparison, looking at the raw data, calling the vendor, asking questions. And I'm pretty sure that that's exactly what happened in this case too, that more than one vendor was actually called to ask questions about what the tool was reporting on. And I think you and I both have done that in other investigations throughout our career, is what we're expected to see and what we're seeing doesn't match with that comparison of manual raw data. And so why is the tool not reporting properly? Is there a bug? Is there a problem? And so again, it goes back to, through a lot of casework, knowledge, skills, ability, training, experience, you have to understand the important, you called them smoking guns, we call them findings of a case that needs to be truly validated to make sure that there is no issues once the evidence is read into court.
Right. And a lot of this assumes that you know how your tool as a whole really works and what it's doing with the data. And as you've been there for a while and been doing some cases, you have picked up the understanding of what is normal, what looks normal, and then you can spot the abnormal because of that. So obviously, if you're a brand new examiner, you've not got that like, ooh, this looks weird, I haven't seen this before sort of situation, because when you're new, you're like, I haven't seen any of this stuff yet.
Right. And that's why a new person should have a person with them that has some experience to, help explain some of the details that might look okay to the new person, but definitely a standout anomaly to a more experienced person.
Yep. And I think Stinger got a bad rap because everybody was like, oh my God, push button forensics at its finest. And they meant that in a bad way because they thought he just was like, click, click, left it alone, conflicting reports, whatevs, but he tried. The sheriff's office tried 4 different tools to generate reports. They tried validating, and by the time they went to trial, they just didn't have any explanation, and their strategy was to avoid it.
Right. And their strategy was right. Their strategy was to communicate that to the prosecutor, to be able to make sure that they stayed within the lane, that they could validate and communicate about the findings and not to cross that line. And unfortunately, again, goes back to who's in control of that evidence and those exhibits that are being entered into court. And those are your attorneys and your judge. When us as examiners are left out of that decision, we have to roll with what we're put on the stand to talk about.
Yeah, and that we even found out there was, when this whole hullabaloo of the 84 versus 1 and the conflicting reports, apparently there was a lot of motions and sidebars and back and forth because the lawyers were apparently arguing about this quite a bit. And at one point, I guess the judge was just like, you're going to have to end this and live with it. It is what it is at this point. And so that's other stuff you don't see, right? Because the jury, they can't hear the sidebars or any of that sort of stuff. And some of this stuff is obviously happening behind closed doors. So the media didn't hear any of that either. Because
Right.
there was a break between Bradley's testimony. He went on like all afternoon. They got dismissed for the day. And then he had to come back on the next morning. So apparently there was a lot of fighting that night.
We're actually told they weren't supposed to use that size spot. Now, the state did have a digital forensic examiner from another agency sitting in the courtroom. Didn't know that.
Right.
That was there to help with the digital evidence stuff as it came up. And that was a good strategy, right? Like being able to explain some of the terminology that's being spoke about, being able to help with the line of questioning to move the case forward. So that was a good strategy.
I wonder if it was the guy who I was asking Larry about earlier, if that was their guy talking to him. And he's like, no, that wasn't our guy, because there was some guy that was always on his BlackBerry. And I couldn't remember exactly where he sat. So maybe this was the digital forensics expert sitting there for the state trying to help them out.
Yeah, exactly. But they didn't have a strategy for what to do if the defense introduced that conflicting results, and they clearly that defense, that was the defense strategy. And again, it goes back to the fact that if there's discovery of data sitting there and one lawyer doesn't speak about it, but another lawyer does speak about it, it's discovery, right? And so it's open for discussion. It's open for getting that evidence in through an expert. And whether it's the defense's strategy or the prosecution's strategy, the prosecution clearly didn't understand the can of worms that could be opened up by avoiding one area of the evidence and only speaking about the other area of the evidence.
Right. Because even if your strategy was, to avoid, let's not discuss this, let's not mention it up, you have to remember the discovery includes all of the hard drives and laptops in this case. So certainly the defense expert can run all their tools and just see all that stuff. But in this case, clearly a net analysis report was entered in to evidence as derivative evidence. So they saw like immediately there was a cashback and a net analysis report. And, we never did hear was any report written that said this is all conflicting. We don't know why. And then, you could talk about amongst yourselves, is that a good idea to be like, I don't know why they don't match, or just kind of like not document it? I don't know.
Right. It's a difficult situation to be in.
I think I would have documented certainly what I was trying to do.
Sure.
All the different things I did, that would be in my case notes. And then you got to write up what you did in your case notes. And I don't know that I would have had a conclusion of WTF.
Right. Exactly.
Because clearly that was the conclusion before they went to trial.
Right. I don't know what it is. Yeah.
I've never seen a digital forensics written report that says that. I mean, I think we may feel like that from time to time, but we dig deeper, and sometimes you just run out of time.
That's
get
right.
no answers,
Right.
and you're stuck, and that's what happened here.
Yep, exactly. So yeah, sometimes those lawyers skip important questions, and sometimes the lawyers introduce things that weren't involved in the plan in the first place.
Yep. And speaking of plans, the defense strategy basically is throw doubt everywhere. And that certainly couldn't be more true than when it comes to this digital evidence and the conflicting reports. And we have to remember that Larry Daniel is behind the scenes working on the digital evidence for the defense. And he told us, he looked through the cashback reports, the net analysis reports, the written reports, all the stuff that the state had generated. And then he went in, did his own examinations as well. So he knew there was a conflict between the 84 visits or the one visit to that SciSpot chloroform website. And I will say the only advantage you have as a defense expert is you can see everything that the government did first. And you can choose how you want to approach it. Do you want to just look at the raw evidence first and build your case based on what your lawyers have told you is going on and what they need to know? Or do you look at all the state stuff first, the government stuff first? Or do you look at take a peek and then go back and forth? I mean, there's all sorts of different ways to handle that. But I mean, it certainly is an advantage. And I use that to my advantage whenever I can. It's like, well, looky, what did somebody else come up with? Do I agree? Do I disagree? Did I find more? Did I find less? If I found less, why did I miss something? And then figure that out.
Exactly. So what have we learned? We've learned a lot in this case, Stacey. And
Yes.
first, I'd like to take the opportunity to say thank you to all of our visitors and insiders that shared this information with us, that helped us to understand the testimony and the transcripts and what we didn't know. I'd like to thank them openly for coming and taking time out of their busy schedules to speak to you and I about it. So
everybody had stuff that they wanted to say, that they wanted to get out there 14 years later, because so much of what we've discussed today, like the 4 tools, that had never been mentioned before. So there's lots of stuff out there that's never been said. So people think they know Casey Anthony case and why it went the way it did and who did what and who to point that finger at, and bad guy 1 and bad guy 2 and lazy guy 3 and all of that sort of stuff. It's so much more complicated than that.
Absolutely. There were never any 84 searches for chloroform. We know that for sure. And on top of that, we also know that the media exaggerated that. They got it wrong. Like
wrong word.
Morally. Yeah, wrong word.
It was visits, not searches.
It was visits, not searches. When communicating that, the media, explodes things out there for people to misunderstand. And that's what happened here.
Yep, for sure.
Like you said, 4 different tools were used with all conflicting results, which the Orange County Sheriff's Office was not able to validate before the trial, even when they tried, and they definitely tried. So I think there is a huge impression out there that they just trusted the tool results and did no validation. And that is totally not the case here.
Right.
They tried and they did everything to figure out what the conflicts were.
Now, it does sound like they probably could have done a better job of sharing those trials and tribulations of the tool validation with John Bradley, but I know John Bradley was in the position of, I can't see what other vendors do because I don't want to be accused of stealing their intellectual property. So that's
Right.
another sticky wicket thrown into this case as well.
And because that rule was invoked, Osborne and Singer had no idea what happened during Bradley's testimony or during anyone's testimony. They weren't able to discuss it. They weren't able to communicate. They weren't able to listen. And so that also was a situation where it was an unknown for them. Bradley didn't know that there were 4 tools used to try to validate. He didn't know the prosecution was not supposed to introduce the SciSpot chloroform site, let alone the visit count of 84. Likely that knowledge of, was left out from being communicated to him that, hey, we're going to stick with the Google searches and the Google searches only.
Well, and let's remember, before he took the stand, he was under the impression he was only talking about the tool itself. So he thought he was going to get really geeky with it and explain and demonstrate how it does this, that, and the other. He had no idea he was going to read a bunch of URLs into the record.
They're URLs on reports that he didn't create. It was his tool, and he was speaking about his tool, but because he was so well known of the tool, he was used to read in the report.
Now, wouldn't that have been fascinating if Baez would have picked up on that and objected and been like, you can't read that in, it's not your report? Like, I wonder how that argument would have played out in court, what the judge would have ultimately ruled. Would he have said, yeah, go ahead, you developed the tool, read in all this stuff that your tool generated?
Again, a defense strategy. You could go this way or you could go that way, and Baez went this way.
Yeah, I don't know if he knew at the time that it wasn't. See, we've spent like 40 bajillion hours doing all these podcast episodes and the research, and I still have more question of things we didn't ask, because was it Baez's strategy to let Bradley read all that stuff in, knowing and hoping that he's going to introduce the conflicting information? Because I think it's stronger for the defense if the state brings in something and then you go, oh, ho, 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 this is shady and this is why. Because sometimes there's rulings, and I've dealt with this, that the judge is like, oh, you defense, you guys can't bring in this potentially exculpatory information. You can't introduce doubt of this nature, like the third person and that sort of stuff. So who knows what sort of stuff happened in the hearings that made some of this stuff go down the way that it did.
Exactly. And so that's, everything just sort of unraveled with the state revealing the 84 visits to the SciSpot on redirect. And then could the conflicts still have come out once it was time for the defense to produce their case?
Maybe.
Like, who knows?
Maybe.
Probably, but we'll never know. And again, it goes back to what strategy was being used to try and navigate the trial to the testimony, right? What is going to benefit which team the best?
Yep.
That's how it works.
So I think, we've thrown out a lot of new information and we've talked about the lessons learned here. But let's start wrapping up finally on Casey Anthony. I have my adult beverage here this whole episode in celebration of coming to the end of Casey Anthony. Cheers to adult beverages. And we want to come back and be like, this stuff is still important 14 years later. How does this apply today? If you are out there anywhere on the internet and following digital forensics people, and if you're going to classes about your tools, you are still going to hear validate your tools. Don't do push button forensics. Don't blindly trust. Know how your tools work. Take a look at those results.
Call the vendor. Ask them questions.
Phone a friend.
phone a friend, utilize your network, right?
Yes.
If there's something new that you haven't seen, call up a friend and say, hey, help me try to understand what's going on here. Hey, what kind of tool would you use to look at this type of data? I'm seeing something that doesn't look normal. What would you do next? There's nothing wrong with reaching out to your network and brainstorming some different ideas. It's part of today's digital evidence because it changes so often.
Yes, it changes so often, so fast. There's so much more of it from so many more different services and sources. And I think that's kind of the other part of it too, is stay in your lane to a certain extent, depending what it is. There's a lot of things you can do with a lot of different evidence sources coming in, like a computer and the cloud and emails and the phone and sort of stuff. But at a certain point, if it gets very technical, then you might have to pass part of it off to someone else or start calling and asking somebody else to guide you through this and that, or to tell you some different things to get.
Absolutely. There's a lot of different avenues that can be taken there. Absolutely.
And then speaking of, your role as the expert witness versus the role of the lawyer, that still pertains today. We still have to remember that today. And I don't know that I hear enough about that. I don't know that I've said much about it ever, like even when I'm teaching classes. And I think it's something I want to start incorporating more. We all know our role as the expert witness is to produce the facts and make them easily understood by the jury. But we also have to remember the lawyers and the judges are deciding what even gets in as evidence in the first place.
Yeah. It was stated this week, we're the witness. We are there to provide the information that needs to be read into court, and the attorneys and the judge are there to make the decision on what gets into court. Well, I hope you found the insider knowledge revealed in this case as fascinating as we did. We also hope you found that this case was very interesting and how it all came down. So we ultimately learned there wasn't a bad guy who botched the digital evidence. There wasn't anybody just pushing buttons in their tools and blindly trusting the results, thank goodness.
Yeah.
It was complex. It was complex evidence, and unfortunately, the conflicts didn't get resolved before trial. With that, until next time, stay safe, stay sharp, and as always, keep parsing the truth one bite at a time.
If you enjoyed this episode, make sure to follow us to get notified the next time a new episode drops. If you can do more, head on over to parsingthetruth.com and donate by clicking on the donate button. Parsing the Truth is a nonprofit organization, and we are raising money to send a new digital forensic examiner to IASIS training next year in Orlando. Thanks.